calling the final case of the call, Knier, Powers, Martin, and Smith, LLC versus City of Bay City. This is a mini oral argument on the application, 15 minutes per side. Mr. Powers, you may reserve some time for rebuttal if you'd like, but we just ask that you keep track of it.
Thank you, Your Honor. I'd like to reserve 2 minutes for rebuttal.
Go ahead.
Good morning, Your Honor. My name is David Powers. I represent the appellant, Knier, Powers, Martin, and Smith, LLC. And what I would like to talk about today is Proposal A. In 1994, the people of the state of Michigan passed Proposal A, which was to limit the increase in a property's taxable value to either 5% or the rate of inflation, whichever is lower. The only exception to that limitation was for additions, and that's the word that we're here to talk about today. The issue that I would like to focus on is whether replacing the roof on our office building, which was basically just taking off the old shingles and putting on the new shingles, is an addition within Article 9, Section 3 of the Constitution created by Proposal A. Our position is that the answer is no, that just by taking off the old shingles and putting on new shingles, we did not create an addition to the building. Now, the Constitution doesn't define the term additions, and so normally we would look to the rule of common understanding. But with this statute, this court has already determined in the WPW case, WPW acquisition case, that we must use, that the term additions is a technical term that those sophisticated in the law understood in 1994. And so this court said we have to look at the statute defining the term additions as it existed in 1994, and that is MCL 211.34D. So from my vantage point, this is a very simple case. We just have to look at what the court said in WPW acquisition about the definition of additions in the 1994 statute. And at this point, I'd like to read the statute.
I just have a question for you.
Sure.
I remember spending about 5 years on a case that we fought over the definition of what is an alteration versus what is a repair. It was whether a stadium had altered the facility or had they repaired the facility. And that came with it a lot of issues as to whether or not if it was a repair, you wouldn't have to bring it into ADA compliance. If it was an alteration, you would. The reason I bring that up is it's so similar here. Do you feel that the legislature had intended for a situation where ultimately you could have a storm that could rip apart the roof, and then you fix the roof, and that would not be considered to be an addition? But if you do it out of routine maintenance, that is considered to be, from the arguments that are being put forth, an addition. I mean, do you feel that the legislature really intended for a business like yours, if you're doing routine maintenance, to have to pay a 12.5% increase in taxes?
I mean, the answer to that, very briefly, is no. I don't think that that was the legislature's intention. And you simply have to look at the language of the statute itself, which I'm not actually here to argue the statute, because I believe that the Constitution is the thing that we should be looking at, because of the Constitution.
Counselor, if we're going to look to the Constitution, do you think that the tribunal had jurisdiction to decide the constitutional question below? And if not, what impact that has on our decision today? So let's imagine there's argument by amici that there wasn't authority, jurisdiction specifically, to litigate the constitutional question below.
So, Your Honor, with due respect, I had a lot to prepare for today, and the jurisdictional issue was not on my slate for today, and I have not prepared any time thinking about that. Thank you.
So if I can direct you to the statute, because maybe if we don't have to get to the constitutional question, so addition it seems like in the statute is really the antonym of losses, and so maybe the common sense isn't as much there, but really aren't we required to look at whether it's new construction? And I think that you're, under the statute, that would be your argument, that this does or does not fit under the new construction provision. And specifically, I'd like your interpretation. There's the language in that provision that says, subject to the provisions set forth under section 27, right, which has the list of repairs, but also refers to true cash value and refers to residential properties. So how would you have us read that specific language in the statute?
So I'm having a little trouble hearing you, but what I will say is you seem to be talking about the statute of 27, which was Matthew Gast amendments.
Right, so this is the definition of new construction. So additions, the new construction provision, that then refers to section 27, A through Q, which has the list of repairs in it. So how would you have us read that provision, subject to the provision set forth in section 27? What does that mean?
Your Honor, I'm just not in a position to answer that question. I'm sorry.
That's okay.
I'd like to talk about the 1994 statute defining additions. And I think it's the time that we have to actually read the statute, which I hate doing at oral argument, but it's short. All increases in value caused by new construction or a physical addition of equipment or furnishings, and the value of property that was exempt from taxes or not included on the assessment unit's immediately preceding year's assessment roll. So that's the language that we have to deal with, and this court in WPW acquisition looked at the question of whether a value increase due to an increase in occupancy was an addition, and this court said no. And the court said the answer is obvious from the language of the statute itself. And if it's obvious, that's because it either had to be new construction or a physical addition of equipment or furnishings. And so in my view, the answer is really that simple. The 1994 statute speaks of value increases just for those two things. It doesn't say anything about value increases due to an increase in occupancy, and so this court in WPW said they're not additions. Now, it didn't just end with WPW acquisition. The Court of Appeals a few years later in Toll Northville at 367 did the same thing. It said additions are these two things, new construction or a physical addition of equipment and furnishings. And this court in 2008 reviewed that decision, and it specifically approved the court's reference to only those two things, new construction and the physical addition of equipment. So we have three reported decisions which make it very clear that under Proposal A, the term additions is limited to those things, new construction or physical addition of equipment and furnishings. And that brings me to my final point, which is that our replacement roof is not new construction. And I think the point is obvious, but we cited in our brief several cases looking at those two words, repairs versus new construction. And as you can imagine, the cases made a distinction between repairs and new construction. And the city they haven't cited a single case which shows that a roof replacement was new construction.
So Council, we have the Home Improvement Act, which clearly does exempt out roofs from the definition of an addition. So we know there was sort of a decision by the legislature to make sure we incentivize people to fix their homes. We have Proposal A, which of course was largely rooted in kind of a property tax revolt and school funding and a lot of things going on. So we're trying to figure out how to mesh these together. What I'm hearing you say is, should we not really look at the statutes at all? It's just about Proposal A? Because reading the statutes, it seems like we have a special rule for homes that was not adopted for businesses. It seems like they were treated differently by the legislature. I'm guessing you disagree with that difference, so is it your argument we just need to look to the Constitution?
My argument is that the Constitution drives everything. This court has already said it's the definition of additions as it existed in 1994 that controls. And this court said in WPW acquisition that it's not up to the legislature to define the term additions at that point.
But I think, didn't the Home Improvement Act, I think that predated, that was from the late 70s, I think, or, I don't remember the date, but I think it predated Proposal A.
That was 1978, Your Honor, and I just think that is a red herring because that is talking about true cash value. That doesn't have anything to do with the issue that we're talking about today, which is
Except that
additions.
you need to know the true cash value to figure out the calculation for Proposal A, don't you? I mean, there's this capping that you have to calculate it, and then you cap it unless it sells.
Ultimately, yes. And the other distinction that I would like to make about the whole Home Improvement Act issue is that we're not talking about not taxing our roof. Our roof at some point in time is going to be taxed. What we're talking about is whether it's subject to the cap. And so I just think they're completely two different issues. So in the end, Your Honors, the city didn't cite a case that suggested that our new roof is new construction, that it was considered new construction in 1994, or that it even is considered new construction now. And of course, that's why they never addressed our constitutional argument. They completely ignored it at the tax tribunal. And when they finally addressed it at the Court of Appeals, they came up with the term new construction, but they offered no definition of the term new construction. And that's why they couldn't show why a roof replacement is included. They simply said at the Court of Appeals, or maybe it was even this case, they simply said it is. And in my view, we have two reported decisions from this case. We have a reported decision from the Court of Appeals that make it very clear. An addition has to be new construction or a physical addition of equipment.
Counsel, do you have a feeling for how other jurisdictions or municipalities are doing this? Are they treating roofs as additions or not? Do we know? I think both sides sort of profess that this would be a departure, and I'm trying to find out how, as a practical matter, commercial roofs have been treated.
And there's nothing in the record about how roofs have been treated, commercial roofs have been treated. And I think that's very telling. It's been 31 years since the adoption of Proposal A, and there's nothing in the record that suggests that this has been happening in the past. I think the Michigan manufacturers pointed that out in their brief, that the city has brought nothing to the table to demonstrate their assertion is that this is how it's always been. It has not always been, and that's why this issue is coming up before the court for the first time. So, to conclude, Your Honors, we would ask that the court reverse the Court of Appeals. I'm happy to answer any other questions. Thank you.
Thank you.
Good morning, Your Honors. May it please the court, my name is Tom Ammon, and I represent the Police City of Bay City, and I will waive any free fire zone.
Counsel, I'm just really struck by this key issue that I'm having a hard time with, which is if the roof were to blow off in a storm and they got a new roof, it wouldn't be an addition. But since they're doing routine maintenance on the roof and putting in a new roof based off of maintenance requirements, it is an addition. Is that really what the legislature intended?
I believe so, Justice Bernstein, and I believe that is.
Like how, I mean, so I just really want to understand the argument. So you feel that's what the legislature intended for people, if you put on a new roof, that you've made an addition to your property?
Yes, Your Honor, and I believe that to be the case based on the broad definition of addition within the General Property Tax Act, combined with the other provisions in the General Property Tax Act, such as the Matthew Gas provisions, which carve those out, which wouldn't be necessary if it weren't an addition in the first place. Getting back to the replacement construction, that is what I would consider, I suppose, a clarification in the more recent version of the statute. And by recent, I mean this is the statute that's been around since 1995, I believe. And there, I think it's instructive here because the replacement construction means construction that replaced property damaged or destroyed by an accident or act of God. That's carved out from additions. But then the legislature includes some other conditions on that. They said it has to be of substantially the same materials. And also the replacement construction can't be more than 5% greater the amount of square footage. So the legislature is drawing some conditions there and limiting it in certain ways so that if the reconstruction is going above and beyond, based on these legislative lines that are drawn, then it's no longer exempt from the definition of additions, and it's going to be treated as an addition. I think the legislature wanted to create an exemption from additions under the newer statute, which it's entitled to do. It can do that. It could pass a exemption for roofs tomorrow if it wanted to. But what the legislature was deciding is, well, in a casualty situation, we are not going to count those as additions. And I think what it's recognizing is in the, I guess, routine replacement aspect of that. You get into a lot of difficult line drawing problems if it's an upgrade to the property or not. And the legislature just simply hasn't addressed that. And I think then we have to go back to the kind of catch-all definition of additions. And they're treated as such for commercial and industrial properties, which are usually larger properties anyways, and more likely to have a valuation impact from that. And for residential properties, of course, we have the laundry list of carve-outs.
Counsel, I want to jump back to a question Justice Thomas asked, and frankly, a question related to an earlier part of this case. Does the tax tribunal have jurisdiction to address a constitutional issue? It seems like the Court of Appeals addressed it very briefly and potentially wrong. And I guess the follow-up question is, if they didn't have jurisdiction over the constitutional question, how do we unscramble this egg? Like, let's say my view is that, it requires a vacate and remand. Do we remand it to Court of Appeals, to the appropriate circuit court? Where exactly would the case go afterward?
Certainly, and obviously this was an issue raised by the Michigan Municipal League in their briefing, and it is a position that the city took, and there are Court of Appeals cases out there stating that the tax tribunal does not have jurisdiction to analyze and consider constitutional questions. So that is the position we've taken in this case. Now, the Court of Appeals, I agree, did a brief analysis of that and basically cited two different things here, right? It said, on the one hand, they don't have jurisdiction, but on the other hand, the tax tribunal can still consider the constitutional aspects of it, which I'm not sure provides the greatest amount of clarity. The way I've always viewed it is that the Court of Appeals is doing a de novo review of the tax tribunal as far as constitutional questions are concerned. So I guess as a practical matter, the way I've approached it in the past in the tax tribunal is I will raise it with the tax tribunal and then make my argument to the Court of Appeals in that regard, knowing that the tax tribunal does not have jurisdiction to consider it. But I do believe that the Municipal League raised some good points about that in their briefing. If you are doing a facial challenge to, essentially a facial challenge to the statute, which I believe this is, then you would bring that challenge in the circuit court, and then it would go up through the Court of Appeals, through the regular channels, because I think the challenge with having the tribunal have this kind of quasi amount of review is that the tribunal judges they're not experts at the Constitution, they're looking at the code. They're almost always just applying the General Property Tax Act.
And even if it is a statutory interpretation issue, it's, as I think Court of Appeals correctly identified, inseparable from the constitutional issue. And if that's the case, then it can't be in front of the tax tribunal, correct?
Right. I think if we are challenging it on constitutional grounds, that's correct. I think that should be a challenge that litigants should be able to bring in the circuit court if they believe that that's to be the case. And I have seen this before play out where And I think in even some of this court's prior cases, it'll note that someone brought a tax tribunal challenge and then they had that action stayed while they challenged the constitutional aspect in circuit court. So I do think that's a viable path for this, and I think it, as a matter of deciding it in the first instance, I would submit it as a better way to do it than have a tax tribunal judge struggle with this. I mean,
So where do we send it back to if it is a vacate and remand?
well, if it's a vacate and remand, I believe it should go back to the Court of Appeals. I suppose it depends on what I guess what the vacate and remand terms would be. I mean, I believe that the issue that this court requested briefing on was the statutory and the constitutional aspect of the term additions, which is, of course, what we're here today about. So we're kind of already there talking about this issue. But I think if it was remanded, it would be back to the Court of Appeals to analyze the question about tax tribunal jurisdiction and the appropriate way of doing that, if that's what this court decides.
Counsel, I wanted to ask you the same question I asked brother counsel, which is how cities, as a practical matter, how are they, administering this, when they get roof replacement requests or find out about a roof replacement? Are they treating them as additions all over the state, or is this a departure? Is this something new?
Yeah, so I understand there is not a lot in the record about that, and I think it's ultimately not an issue that comes up too frequently, mainly because it's restricted to commercial and industrial properties. But my understanding, and I've been working with the Bay City assessor on this, and he's actually here today. He's very invested in this case. He's been talking to colleagues, other assessors in other jurisdictions, and they agree with his position. But, assessors have some leeway in this because at the end of the day, it's their opinion of how much the specific addition has increased the taxable value of the property. So it has to be specific to that. And in the tax tribunal, what we had here is the appellant initially argued, well, my property, it didn't enhance the value of my property, and that's usually what happens. And eventually that argument was waived, and they just stipulated, sure, it increased my value by this much. But I think that what, as a practical matter, plays out is someone would appeal it to the tax tribunal. They would argue about, my guess is in a lot of cases you could have an appraiser come in and say, look, the market's not going to say, hey, I'll pay a $20,000 premium on this because it has a new roof. And maybe they'll say that, maybe they won't, but it's a fact question for the tribunal to determine. But my understanding, getting back to the original question, is that other assessors have been approaching it in a consistent way. It's a broad view of additions, and that is really to avoid, and I think, frankly, one of the reasons we don't see a lot of litigation in this area is because the statute's broad enough and people can understand, the way new construction is defined, you don't get into these fights over whether, my major upgrades to my commercial space are an addition or whether they're just routine replacements. What's routine? That becomes a really messy factual question.
Right, and as a practical matter, I'm guessing a lot gets worked out at the local level, they reach a resolution, and of course, cost of litigation to appeal when you do all that, yeah. So
Sure.
It's not surprising to me we don't see many of these cases. So, but to your point, the proceedings sort of started out about sort of the value of the increase. That seems something squarely within the tax tribunal's authority or jurisdiction.
Absolutely, yes.
Yeah,
Yeah.
and then it morphed into something else as the proceeding moved.
Yes, and originally, our argument, that's why our argument in the tax tribunal focused on, and you can argue to the tax tribunal under the statute, this isn't an addition, and that's what our argument focused on in the tax tribunal, and the tribunal agreed with us. And we basically said, look, the constitutional question is beyond this tribunal's jurisdiction, we think it's wrong, and we really more fully briefed that issue in the Court of Appeals once we were there. But yes, the tax tribunal, and so I know there's these kind of, arguments on the other side about, well, what about a new coat of paint? Well, in the first instance, an assessor would have to come in and say, oh, that new coat of paint alone, just the new coat of paint has increased the value of your property by whatever the assessor determines. And then, that's again, a core factual determination. It's no different from any other opinion of value that you're contesting in front of the tax tribunal.
Counselor, can I ask you about the provision in the definition of new construction that refers to that list of repairs, or, and how we're supposed to read that, the relationship between that reference and the list of repairs? What's your position on that?
Yes, absolutely. Okay, the structure of the statute, new construction is any property not in existence on the previous tax day. So any improvement that comes in and improves the property is kind of swept into this. And then it also says that new construction includes the physical addition of equipment or furnishings subject to those provisions. So the legislature is acknowledging, look, we have this carve out here. So, we're not going to consider this an addition. We're not going to consider it new construction because we've carved out, reader of the statute, go over to the Matthew Gast Act and make sure that you're not dinging a homeowner for putting a new roof on. So that's how that interplays. And then, of course, there's the carve out for replacement construction as well, which I've already discussed. But I think the legislature was clearly cross-referencing that to prevent, the General Property Tax Act is not an easy statute to read. The longer I've done tax appeals, the more I've realized that. And so I think that was a clarification included in the statute by the legislature to make sure that we didn't run into these problems. Your Honors, unless there are additional questions, I would yield my remaining time. It's almost up anyway, but be happy to answer any more. Thank you.
Thank you. Mr. Powers, you have 2 minutes and 2 seconds.
Thanks. I actually didn't hear anything that I felt that I needed to respond to, so unless you have any other questions, I think I'm done.
Wonderful.
Thank you.
Thank you very much. The case will be submitted, and the court is adjourned.